The EB-1 is under attack. But before we dive into the data, you need to understand the battlefield. EB-1, the Einstein Visa, a green card for the top 1% of talent who can prove extraordinary ability. NIW, the National Interest Waiver, a secondary route for experts whose work is so vital to the U.S. that the government waives the need for a job offer. RFE, the request for evidence, a formal interrogation where USCIS demands more proof before they deny you. NOID, the notice of intent to deny, the ultimate red alert. It's USCIS telling you they've already decided to say no unless you can prove them wrong in 30 days. In 2025, we are witnessing a massive surge in request for evidence, RFE, and denials, with approval rates dropping to roughly 71%. Is this just a backlog or a deliberate crackdown? Today, we reveal the data-driven strategies that are turning these denials into approvals. And the big question we'll answer at the end: is the EB-1 system actually broken? Or is there a specific hidden metric that most applicants are simply missing? Before we break down the evidence, make sure you hit that like button and subscribe to our channel so you don't miss any critical updates on your immigration journey. Here is a question for you to answer in the comments right now. If you received a request for evidence, RFE, from USCIS today, would you know exactly which metric in your career history to highlight first? Let us know below. The approval crash. Let's begin with the hard evidence. We dug into the latest immigration data, updated as of December 2025, and the numbers tell a startling story of decline. In the first quarter of fiscal year 2025, EB-1 approval rates were sitting comfortably at roughly 74.8%. But as we moved into Q3, that number crashed to 66.6%. This isn't an isolated incident. The crackdown extends to national interest waivers as well, where approval rates plummeted to just 54% in Q3, the lowest we have seen in over a year. What is driving this? It is the request for evidence. Researchers have noted that RFE rates are now exceeding 45% for these petitions. For self-petitioned cases, that number is often estimated between 40% and 50%. This statistical shift proves that USCIS has launched a broader push for rigorous evaluation, essentially actively looking for reasons to pause your case. However, veterans of the industry know that this is part of a pattern. As attorney Chris M. Ingram notes, "In my 20-plus years specializing in EB-1 cases, I've seen cycles of increased scrutiny, but our firm's tailored strategies have consistently turned RFEs into approvals by focusing on irrefutable evidence of impact." Have you or a colleague noticed this recent spike in RFEs in your own circles? Drop a yes or no in the comments so we can gauge the community impact. The numbers are down, but the scrutiny is up. Next, we need to talk about why your evidence is being rejected. If that data has you worried about your own visa journey, you don't have to face these statistics alone. Head over to breakthroughusa.com right now. This is where you can start your official visa journey. We are offering a free consultation with the law offices of Chris M. Ingram to assess your eligibility. Don't let a 30-minute review by an officer determine your entire future. Get the experts who have been winning these cases for over 20 years. The impact trap. We've seen the numbers drop, but what is actually happening inside the adjudication centers? Our investigation uncovers a critical shift in policy. USCIS is no longer accepting general claims of excellence. They have pivoted entirely to measurable impact. This means a scientist can't just describe groundbreaking research. They now need to show specific citation counts or patent impacts that benefit the U.S. economy. A tech entrepreneur can't just have innovative software. They must prove it creates U.S. jobs. Why the rush to deny? Anecdotal reports suggest adjudicators may have as little as 30 minutes to review petitions that span over 200 pages. In that high-pressure window, if they don't see hard numbers immediately, they issue an RFE. This subjectivity leads to massive inconsistencies where two officers can look at the same file and reach opposite conclusions. As attorney Chris M. Ingram explains, the solution is in the evidence. Our secret to consistent EB-1 success lies in curating recommendation letters that don't just praise, helping clients overcome even the toughest notice of intent to deny, NOID. Does your profession have easy metrics like citations or sales, or is your impact harder to quantify? Tell us your field in the comments. The standard has changed, but the strategy to beat it is already here. Next, we build the fortress. The fortress strategy. How do you beat a system that is designed to find cracks in your armor? You build a fortress. Our investigation confirms that the single biggest mistake applicants make is submitting a good enough petition and hoping for the best. That is a guaranteed recipe for an RFE. To succeed in EB-1A, you must satisfy at least 3 of the 10 strict criteria. But in this new climate, simply listing awards or articles isn't enough. You have to front-load your evidence. This means every claim of sustained a claim must be immediately backed by detailed narratives and quantifiable metrics, like citation counts or economic impact data, right in the initial filing. Data from 2025 suggests that this front-loading strategy can reduce the likelihood of receiving an RFE by as much as 50%. It is about removing the adjudicator's ability to doubt you. As attorney Chris M. Ingram emphasizes, despite the 2025 surge in RFEs, our data-driven rebuttals have maintained over 90% conversion rates, proving that preparation trumps panic every time. Looking at your own career, which 3 of the 10 EB-1 criteria do you think are your strongest? Awards, high salary, original contributions? Let us know below. You have built the fortress, but now you need allies to defend it. Next, we discuss the one piece of evidence USCIS trusts more than your own word. The inner circle mistake. You have the data, but do you have the endorsement? A major red flag we see in denied petitions is the inner circle mistake, relying on letters from colleagues or mentors. In the eyes of a cynical adjudicator, these are biased. To win, you need independent validation. Our investigation shows that weak or affiliated letters are a primary trigger for notices of intent to deny. The winning strategy? Securing endorsements from impartial experts worldwide who know your work, not your face. USCIS demands specifics. They don't want to hear you are a good manager. They need to see that your innovation improved industry efficiency by 30%. It's the difference between praise and proof. I want to hear from you. Do you have an expert in your field, someone you have never met personally, who cites or uses your work? Yes or no? Your letters are signed, but there might still be a hole in your story. Next, we look at how to find the missing pieces before USCIS does. The data defense. Even the best petitions can have blind spots. Our investigation reveals that self-petitioned cases frequently face RFEs, questioning future job prospects, or ambiguous impact. The danger is real. If you receive a NOID, you may have only 30 days to save your case. This is where you must pivot to data. You cannot simply argue with an officer. You must overwhelm them with facts. We are talking about supplementary affidavits and comparative studies that statistically prove your work serves the national importance of the United States. This ability to close the evidentiary gap is what saves petitions. As attorney Chris M. Ingram states, "We've navigated evidence gaps for over 2 decades, turning client worries into wins by sourcing endorsements that USCIS can't ignore, even in the face of 2025's tougher standards." Let me know in the comments, when was the last time you had to produce a document under extreme time pressure? We have plugged the holes, but there is one final variable that buys you speed but costs you money. Is it worth it? The price of speed, $2,805. Finally, the $2,805 question. Is premium processing worth it? It promises a decision in 15 days, but does it buy success? Our investigation suggests no. Approval rates remain flat at 71.4%, regardless of the fee. In fact, speed often increases your risk. Officers on a strict 15-day deadline may issue an RFE just to buy time rather than denying outright. However, for families facing visa expirations, that speed is vital. Whether you choose speed or patience, the antidote to anxiety is confidence. As attorney Chris M. Ingram emphasizes, despite the 2025 surge in RFEs, our data-driven rebuttals have maintained over 90% conversion rates, proving that preparation trumps panic every time. I want to hear from you. Would you pay $2,805 for a 15-day decision, even if it meant a higher risk of an RFE? Let me know in the comments. At the start of this investigation, we asked, is the EB-1 category broken? Or is there a hidden metric that applicants are missing? The answer is, it is not broken, but the rules have changed. The hidden metric is no longer just excellence. It is measurable U.S. impact. USCIS doesn't just want to know you are good. They demand data such as economic growth, public health, or cultural diplomacy, proving your work specifically benefits the United States. Prove that, and the prize is yours. Don't forget to like and subscribe for more investigations into the immigration system. If you want to find that metric in your own career, visit breakthroughusa.com today and book your free consultation with the law offices of Chris M. Ingram. I'll see you in the next video.